Honourable judges, ladies and gentlemen, Assalamu alaikum. I'm going to provide you with an international context for our discussion on various forms of dispute resolution and in particular commercial courts. It is well known, well accepted that in recent years there has been an exponential increase in international arbitration worldwide as a trusted form of dispute resolution. But in parallel with that, there has also been an exponential increase in commercial courts worldwide. These are courts that are catering for particular needs in terms of streamlined, efficient, and trusted dispute resolution, often in the English language or the language of the business itself, often catering for non-domestic needs. And these have grown up now in all parts of the world. Famously, the London Commercial Court, which is now over 100 years old, it actually caters for 80% of its users are not from the UK. But we now see it in Singapore, we see it in the Middle East, the DIFC in Abu Dhabi, in Qatar, in Bahrain. We see it throughout Europe, France, Germany, Switzerland, in countries such as Kazakhstan and in China. These are all countries that are not only promoting arbitration, they are also promoting commercial courts. And it's important for us to understand why that is, because there are key lessons for Pakistan if we do so. You can distill 4 key drivers for the establishment of these commercial courts. And those 4 drivers apply to Pakistan as they apply everywhere else. I'm going to identify them very briefly. Firstly, there is a critical relationship between international arbitration and court. There is a common misconception that somehow arbitration and court are in a relationship of competition and antagonism. That is because people resort to arbitration because they're dissatisfied with court. But that actually belies a key relationship between the two. What has been found in successful seats around the world, those are countries that have successfully developed their international arbitration system, is that there is a critical symbiotic relationship, an interdependence between arbitration and court. And in fact, in order to promote alternative dispute resolution, what one has to do is promote a wider alternative dispute resolution ecosystem. The ecosystem has a number of components that all relate to each other. One of them will be arbitration. Another will be other forms of dispute resolution, such as mediation. But critically, there will also be court. Without a successful, efficient, and trusted court, you cannot have a successful, efficient, trusted arbitration system. And Pakistan is the greatest example of that, because arbitration here, if we're honest, is a precursor to litigation. Because the court system is not at the moment, or historically has not been strong and supportive and efficient for the arbitration system itself has been weakened and has not properly developed. The second key driver for commercial courts is the realization that if court is critical to arbitration, it's got to be a specialized court. So whilst court is looked to support the arbitration system, during the whole course of a normal arbitration from beginning to end, the court is there in a supervisory capacity. That simply doesn't work unless the court itself understands arbitration. And that has led towards the need for specialized judges served by specialized counsel. And that has been the real genesis of commercial courts. That is a forum that's technical, that's efficient, it's expert, but it really understands the concept of arbitration. And therefore it restricts the court process to one of support, but not intervention. The third driver, which is incredibly important for Pakistan, and I think has not really been appreciated adequately, is that if you build an ecosystem for dispute resolution in this way, you actually promote Pakistan generally as a host for foreign direct investment and for broader development. Capital is free-flowing. It flows to those countries where there is trust and confidence. And indeed, an efficient method of exiting a project is as important as the initial entrance into a project. The whole system, the whole chronology of an investment requires there to be an effective form of dispute resolution. And so if you build the ecosystem, which means efficient arbitration, supported by an efficient court, then the host country becomes attractive for foreign investment. It becomes an environment where you will have naturally more development in many, many different ways, both legal and non-legal. And that leads to the fourth driver, which is also incredibly important. If you develop an efficient, trusted system of dispute resolution with all its dimensions, arbitration and court, there are a number of side effects which are extremely significant. Firstly, empirically proven by many countries, you have invisible earnings. You will have more people coming to the country spending money. You have actual economic development around the periphery of the dispute resolution process itself. Further, you develop jurisprudence. With specialized courts, you have more specialized judgments. And so the law becomes more sophisticated and thereby more trusted. People trust English commercial law. That's because of English courts. And a lot of English commercial law actually is derived from arbitration. Most of English contract law for many, many years has come from cases stated from arbitration to court. So you get invisible earnings, you develop a more sophisticated, trusted jurisprudence, and then thirdly, critically, you raise standards generally. Because if you have a functioning commercial court that is reflecting international standards and norms, then local counsel get exposure to a system they might not otherwise have contact with. And that raises standards generally, not just within the commercial court, but more broadly even within other courts. And that means overall development and an overall expedited way to get to a trusted system that will give confidence and overall improve the overall legal scene. I just conclude by saying that Pakistan is now on its journey to get to this ecosystem. But it is a journey that is specific for each country. And what Pakistan cannot do, and history has shown that it cannot do, is simply import from other countries without crafting something which will work locally. And that is where the Chartered Institute has a singular importance, because Pakistan needs training. This system will not work unless everybody buys into it. And to buy into it, you need to understand it, and that means training for arbitrators, for judges, for counsel, and for users. That is something which is a collective good. It is something we should all now be supporting, and this, I would suggest, is the beginning of hopefully now, at long last, a successful journey. Thank you very much.